What's up, Highland?
What's up, Highland?
Got a very interesting guest today. We're going to let her sit over here and squirm for a second. We do want to remind everyone to follow What's Up, Highland on Facebook, YouTube. You can get notified of the episodes right as they come out. Still have, weeks and weeks of guests coming up. We do have our 50th episode where Ryan, Jeff, and I are going to kind of just do a little powwow and reminisce on some of the guests that we've had and maybe some of our own thoughts and see if you people actually like our real characters when we're not interviewing anyone. But today's guest is a value add, I think. Being in the financial planning industry, Paige is one of the resources that I feel like every person should have at their discretion. It's something that a lot of people don't want to think about. It's hard for them to get over the hump on maybe some of the expenses, but what a value that someone like Paige can offer to your future, to your legacy. And we'll kind of let you explain a little bit, but we're here with Paige Fox with Paige Fox or Fox Elder Law and Estate Planning. So Paige, why don't you tell us a little bit about who you are, where you're from, a little bit about your journey, and if you want to get into your being you have to correct me, as an aspiring trapezist. Is that the
trapeze artist? I guess.
Trapeze artist. Okay, so little secret there, but tell us a little bit about you.
Yeah, for sure. So I will have been practicing law 10 years in November. And I've focused my practice on both estate planning and elder law. I would say there's a lot of overlap there, but the estate planning aspect is what we're here to talk about. So, I started at a small firm. I went to a larger firm in Chicago, and then in 2023, I decided to open my own practice. After the COVID stuff and everything going remote, I felt like I could do my job just as well as I was in person remotely. And so I opened my own fully remote practice while I was still up in Chicago. And I just recently moved back to Highland. And so now I'm practicing in the Highland area and also in O'Fallon. I work at Dent Colson Elder Law as well, part-time. So a lot of my focus is on estate planning for, the elder law side of things, but also a lot of younger couples. One of the things that helped me decide to go fully remote was just the costs of everything, and the cost that we were, having to charge people for their estate plans kind of seemed outrageous to me. So I figured, if we could do a lot of things remote, drop the overhead of rent and everything else, we could drop our prices, and that would allow younger people to start doing estate planning too. Because, the longer I was practicing, the older my friends were getting, and they were having kids and getting houses and everything. But you tell them the price of it, and no, I can't afford that right now. I have 2 kids in school. That was really my main goal, was to be able to drop prices and just make it more flexible for me and my associate attorney to work. So, yeah.
Good story. Mm-hmm. So I kind of curious of like how to jump in here, because there's kind of 2 different things that I think you could start with. One is there's 2 different, when you're talking about trust, there are 2 primary levels of the trust work, and then it's a lot of people think I've got a will and I'm good. What's your opinion on that? Because I hear it often in my profession, and I know from doing my own estate planning. I'll let you share, but tell us about a will versus an actual trust.
Yeah, that's a very common thing that comes up almost right away with most clients is, do you have any current estate planning documents? What are they? A lot of people do have a will from like 20 years ago sometimes, or I always use my parents as an example. They had a will that existed before my brother was even born. And they were like, but we don't need a trust. We don't have a bunch of money. And like I tell all of the clients, it's not really about money as much anymore as it is the type of property that you own. So in Illinois, if you own any real property whatsoever and you pass away and there's not somebody else on the deed, or you don't have some transfer on death instrument in place, it goes to probate automatically. If you have property in Illinois and Missouri, you have to open up a probate in Illinois and Missouri.
Before you go, and I like where you're going, could you just explain what probate is for those that don't know exactly what that is?
Yeah, for sure. So after somebody passes away, if you have an estate, So anything that you own, cars, vehicles, bank accounts, real property, you basically, all of that has to come together, pay any outstanding expenses, and then your estate, whatever money is left, is to be distributed to your family members. If you have a will or a trust in place or some document that specifies where you want your money to go, the money will go that way. If you don't, there's probate laws that explicitly say, okay, if you have a mom, this much goes to them. Or if you have a spouse, this much goes to them. And so basically it's the court process that you have to go to settle your estate after somebody passes away. And probate requires 6 months at least of court. Oftentimes there's attorney fees, expenses. Creditors are able to get to you within those 6 months. There's a lot of downfalls of probate. And it's just not as simple or quick as a trust administration can be. And so if you only have a will, that's what happens. You get thrown into probate unless you have less than $150,000 to your name and no real property. So what I was saying is most, or a lot of people, at least when they're coming in to do an estate plan, have real property. And if you own real property and you only have a will, it's guaranteed that you're going to probate court, essentially. And at this point in time, I would say my average simplest probate estate, $6,000 to $7,000, and at least probably a year of time. That's at least 1, maybe 2 court dates. Some courthouses and some counties. On
top of dealing with the loss that someone's had too, something that you do not want to really deal with.
And a lot of people, it's amazing how many creditors and stuff will come out of the woodworks and hound you about these things because you're vulnerable at that time. You're grieving, you're going through all of these things. And so you just pay them or do what you're told, and it's messy. It's messy. It can be very lengthy. It can be very expensive, and it can all be avoided by having a trust.
Probate sounds like on The Lion King when they just said Mufasa and they all chilled. Nobody wants Mufasa. Nobody wants probate.
Say it again.
Mufasa. They should change the name of probate to Mufasa.
Great reference.
Thank you.
And I'll say that probate is required sometimes. So if you have a minor guardianship, if you have minor children or something, a will is needed and probate will be needed, but it's a different type of probate and you can avoid the estate.
But you don't want the court system delegating where your kids are going to go. Going back into, which we haven't really got into the trust thing, but the trust really can allow you while you're in your faculties and everything to make those designations as you wish instead of, because you just don't know how people's, peripheral lives are and their families and things like that. There's a lot of risks there.
Oh, absolutely. And the amount of different family dynamics that you see is, there's no number to it. It's just ongoing. There's so many different dynamics. And the thing about a trust allows for that flexibility, to fit the certain situations. But yeah, oh, go ahead.
No, you go ahead.
I was just going to say, so getting back to, because there's so much you can go into there, because there's a lot of different types of trust. There's the irrevocable, there's a revocable trust, there's also special needs trust. So there's a lot of different planning that you can do. But I would say the will is the most basic known one. And it used to be really the most common one for anybody who was middle class or anything, because probate was fine. But with the expense of probate and the time length and everything, revocable trusts are way more common for a lot of people than it used to be 10 years ago.
This may be a 2-part series. You got a lot of. We haven't even scratched the surface yet.
Really.
At what point does someone need to start looking into this?
So, I think that anybody over the age of 18 should have a power of attorney for property and a power of attorney for healthcare. And I would say, a will is a different story. A will tells you where you want your assets to go after you pass away. Some people who are turning 18, 19 years old, I know I didn't have any assets to give away at that point in time. So, but the problem is once you hit 18, you're a legally an adult and nobody has the ability to make decisions for you. And you don't realize that until all of a sudden a parent's trying to make a decision for their adult child who's in college and you can't, or you're not allowed to get access to records. So when my brother and sister were like going off to college, I gave them for their birthdays powers of attorney, which I learned from my boss who did that for his sons as well. Because, you know, for me personally, I got in a car accident my freshman year of college, and my mom had that problem. She didn't have a power of attorney for me, and she couldn't get any access to the medical information. And so now, yeah.
I can see how well that went. Thanks, Aunt Paige.
Yeah, yeah, exactly.
Mom.
They loved it. And maybe it was for Christmas. I don't know. They were thrilled.
That's funny.
It's a new idea for me for this year. Can't wait. It's a human fund. Okay, so you actually mentioned one that and we'll get to that too. Again, I think we're going to break this up into two parts. But you mentioned the special needs trust, which I really want to touch on after we get talk about the revocable and stuff. But the special needs trust, I don't think is a very well known vehicle that's out there. But I personally have a couple clients that have utilized the special needs trust. So when the time comes, I am out there talking to those clients that maybe have that situation. While we're on it, let's just talk about what the special needs trust does, because we're getting into, some of the disability stuff from Social Security, and if you have a disabled child, and how we want to protect, them to be able to continue to receive some of the benefits that they're entitled to. So, go ahead and I know I'm kind of bouncing off, but this is an exciting topic for me because you're passionate, but I want my clients and really anyone that has the gaps, they need to be filled. So anyway.
No, absolutely. And I'm just going to really quickly. So there's the will, there's powers of attorney for healthcare, power of attorney for property. There's trust. There's the revocable trust, which is a very common trust that's what I would recommend for most clients.
You can change that at any point in time.
It's a grantor's trust. It doesn't impact your taxes. It uses your social security number just like any account does. So that's that bubble that's created to prevent probate. And then there's irrevocable trust. There's numerous different types of irrevocable trust, but that's the type of asset preservation planning type trust that you're talking about. Because once you put an asset into an irrevocable trust, you can't touch it. It's not yours. We use that sort of thing for like farmland, to protect it in a family situation if somebody needs to go on Medicaid for long-term care. There's a bunch of different types of irrevocable. And then there's the special needs trust. And within the special needs trust, there's third-party special needs trust, there's first-party special needs trust, there's numerous different types. But a first-party special needs trust is where the person who has a disability puts their own money into a trust that is then protected and not eligible and does not impact their benefits in any way, shape, or form. The difference between a first party is that if there's money left in that trust after you pass away, that money has to get paid back to the state of Illinois for what they've paid on your behalf for public benefits. Whereas a third-party special needs trust is created by somebody else. So in a situation that I see very often is parents come in. We have them do a revocable trust, and let's say they have 3 kids. So they want their assets to go to their 3 kids equally after they pass away. But a lot of times if parents have a child with a disability, they will have written them out of the will completely and basically told the kids or a family member, okay, we're not going to give them money, but make sure that you use your own money. That doesn't work.
Will they? Will they? That's the variable.
Question. That's a big question. They're not required to, but also even if they do, what are the impacts on them from a financial perspective and the tax hit, not everything that gets. So it makes it cleaner to, instead of writing 50-50 to my 2 kids and then counting on them to give money to the third, it's a third to each, except for the third of it goes into a third-party special needs trust for the child with the disability. And then that money is set aside in a third-party trust, and it's not eligible or it doesn't count towards their assets or their income for purposes of getting on public benefits to cover their health care and anything like that.
It's an amazing tool.
It is.
I think, again, I think it's one of the most underknown, however you want to phrase it, vehicle, however you want to call it. I just think that there might be literally someone sitting out there right now that, could be putting some of their, their benefits into maybe not even in because you can't build up certain assets even in a bank account So maybe they're sheltering those in other those benefits that are coming in other places that don't really have the instruction. So just on that topic, if you guys are out there and you're in one of those situations, she's personally, I know how they work. But I would reach out to Paige on that one. It's just what a good thing to do for your family and remove infighting, remove all the confusion things. Don't put that pressure on the people that shouldn't need that pressure put on them.
Absolutely. I mean, and it makes it cleaner for everybody. It's clear instructions. Everything that you do is already for sure allowable under the different Medicaid policies, Social Security, disability, all of that stuff. And so it's very strict how the special needs trust is administered. But in short, as long as the money that's paid from it is paid on behalf of the person with the disability and it's not being paid towards something that would have otherwise been covered, so medications, treatment, all that sort of thing, then it's good to go. And it's a huge tool because, it worries, like I see it probably daily, or not daily, weekly. Somebody comes in and they've suggested like the distribution that I mentioned to two kids and not the third and so on, because they had no idea that they could set up a third party special needs trust. But what's nice about that third party trust is, like let's say parents set it up for their child. If a grandparent is planning on leaving money to that grandchild also, they can change their estate plan to give it to the trust instead of to that child directly. And so anybody who's leaving money, then it goes into that trust and it's never considered the person with the disability's money. So then it can't count towards assets or eligibility.
Just good planning.
Yeah. And it's not super, super complicated. I mean, you can name different corporate special needs trustees, to make sure that it's managed correctly. Like I use Life's Plan often for first party trusts, for the pooled trust. But family members can do it too, and I always would talk through it, who you want to name in those different roles and everything, not only for the special needs trust, but your regular trust or any other documents that you do. It's something that we would talk through so that, you name enough people in the right order that you want so that you can sleep at night, knowing that if anything happens, whatever happens, you're covered.
Yep.
And I feel like because people don't like to think about it, people don't like to think about death. People don't like to think about if something happens to them. That pushes the estate planning out of their mind and like, well, if I don't think about it, it's not going to happen. But I will tell you that if you just get it done, you can put it back. And, it doesn't, just because you have an estate plan doesn't mean you're going to get in a car accident tomorrow and now you're gone. It just means that you're good to go. Whatever happens, something is in place.
Could we, by chance, I know if you're have a tough time processing this, like this is all, I'm like taking water with a.
Watch, I'm glad you're here because this is her space. I'm familiar with it.
And I feel like I even have a little bit of a decent grasp on finances and whatnot. So let's think of a problem or a situation with a typical household, maybe someone who owns a $300,000 house. They have two kids that are in high school, and they both have a 401k that they're building up, and they both have good jobs. That's a typical Highland household there. They don't see anything wrong. They don't see that there's a problem. You would say that there is a problem. Like, what is the problem with the situation, or what is it? What is a problem that could happen to them that they need to fix with these type of situations? With this.
I like that you brought up the different scenarios, because I will say it's going to be different depending on each individual circumstances. But in that situation, I would say the fact that they have minor children would be my number one concern, because no matter what, so if something were to happen to one or two of the parents, both parents, who is supposed to take care of the children? And that's the biggest thing that would be covered by an estate plan at that point. So you can make sure to name in your will, okay, if something happens to me and my spouse, we want mom A to take care of them. And if mom A can't take care of it, then sister B. And, name different levels so that instead of leaning on a court to make that decision for you.
So, that's a good question, because a lot of times people think, well, if something happens to me, well, then obviously my wife's going to take care, or if something happens to both of us, then, well, of course, someone, grandma and grandpa's going to take care.
Now, we did pivot.
But is that the case?
We did pivot from the special needs. Now we're talking about the revocable side.
I think we're talking standard estate planning.
Okay.
So yeah. Let's
because I don't want people that are watching think we're still hung up on. We segued.
Yeah, sorry if I segued.
No, that's okay.
No, so let's go. Let's use that scenario. So let's say there's the two parents. They have two minor kids. One of them has a disability, let's say, and the other child is still a minor kid. An example, and they own that $300 house. One thing I would say is almost certainly not knowing all of the details, but saying just based on the house, the minor kids, the disability, what I would recommend right away based on that would be a revocable trust. And within that revocable trust, you identify where you want your money to go, and you identify who you want to assist if you can't do it. And then you can identify also who is in charge of the kids' money. So in the trust, I often do what's called an embedded kids trust. And it basically says, okay, so if something happens to me and my kids are under the age of 21, I want their portion of it to go into a trust for their benefit within that trust, to be kept there, to be controlled by whoever they name. And that person is in charge of paying bills for that child, or, paying for school expenses, that sort of thing. And then at age 21, all of the money can go to that child and it's theirs, that sort of thing. But moving back, so one of the things you would cover would be the distribution, but also transferring that house into the trust would protect you from probate after if they were to pass away. That is the key there. The minor kids stuff would be within the will, and you can identify who and when you want to name it. And then the special needs part, like we were talking earlier, they could create a third-party special needs trust and then have 50% go to the one child outright or via the embedded trust, 50% to the special needs trust for the benefit of the child with the disability. And then from there, once you put everything in your trust, then you're good to go. You just moving forward. Things like
does the will go in the trust, within the trust?
No.
So you're saying that where there is a will, and it's good to have a will and a revocable trust.
I would say that anybody who has significant experience with estate planning would never do individual documents for people. Like, we always do packages. So if you do a will package, that would include a will and a power of attorney for healthcare and a power of attorney for property. And then a trust package would be a trust, POAs for powers of attorney for healthcare and property, and then the will also. It's just a different type of will. It's called a pour-over will. Make it more confusing, but it's just a different type of will. But within the will where you identified the guardianship stuff. Okay. So, I mean, because I know it's very complicated and overwhelming, we do like estate planning. I have like this form that I send out to people that kind of identifies these are the decisions that you need to make, and little blurbs about like, pick somebody who's financially responsible, pick somebody who has the same ideas or understands what your wishes are for medical treatment. All these different things to kind of help people make those decisions, because that's also something that people don't think about.
And let's not, while you're on that very topic, those are not easy decisions.
Nope.
We have a split family. I have a son, my wife and I, and then have a daughter from a prior marriage. And once we started doing the estate planning, we realized how challenging some of the decisions that we had to make are. Because my daughter is 26, my son's 9. What's going to happen to him? And it got very emotional at times. So, I mean, the stuff that you're talking about, I don't want anyone to think these are light decisions. They are very important, and you're going to have, some very deep conversations with whoever you're doing your planning with.
Yeah, absolutely. And I mean, it's also, there's so many different family dynamics out there. No family is exactly the same, especially nowadays. You have so many blended families, so many different ages. I'll use my family as an example. My siblings are 10 and 11 years younger than me. And so when my parents did their estate plan, one of the things was the guardianship. Well, I was of age. I could easily be their guardian, but I lived in Chicago. My siblings were in high school or, middle school. So if I would have had to take over at that point in time, what I would have had to leave my life, or I would have made them pick up and leave their life, that's all already traumatizing, and so the decision of picking someone local, making decisions like that, you can build in flexibility of like, so for example, my parents, they had my aunt and uncle named as guardian first, with the stipulation in there that if I was back, or if I wanted to come back and I was able to, then I could step in as guardian. There's just little things like that. Another big thing is the healthcare decisions. Your ultimate 27-year-old, it seems like she's an adult, but you're still her parent. And so asking a 27-year-old to make a decision about, lack of a better term, pulling the plug for like a family member, it's not easy, whether or not you're adult. So there's so many different things that kind of come with all of that. And I just always say, like, whatever feelings you have, they're not wrong. Because it's a lot, it's overwhelming. And some people have 8 different people that they trust to help with their kids if something were to happen. Other people have 0 people in their family that they trust. You see it all. And the nice thing is as long as you plan for it, there is something that we can do to make sure that you're covered and that your wishes are followed.
You're really giving some great insight here.
So we've talked about when you first turn 18, talked about if your kids are younger of age and you are in your middle ages here and you're getting ready for retirement, things of that nature. What happens when we get to retirement? Does things change? The two main things that I would like to have you kind of elaborate on a little bit more is when we get to the age of retirement, and then when we get to that age where we're looking at nursing homes or things of that nature. I would love to see what might need to happen once we get to those stages in life as well.
Yeah, absolutely. So again, let me just preface by saying that the biggest difference between a will and a trust, and the biggest reason people don't think they need a trust, is because there's going to be a price difference no matter which attorney you go to between getting a will and a trust. I will say, make sure to ask that attorney, what is the difference in the pricing for probate too? Because it'll be cheaper now, but you're going to end up paying more in the future with the probate stuff. And so for a younger family, I think the biggest concerns are usually, okay, do they own real property? Is there minor guardianship involved? Is there a disability or special needs planning that we can do, that sort of thing? Middle age and older, it's not the minor guardianship is the thing anymore. It's Medicaid planning for long-term care is something, but also like, do you want to do pre-planning? Do you want to start putting things into, or put something into an irrevocable trust so that in 5 years, if somebody needs to go into a nursing home or something, that asset is protected?
You're referring to the look back period. People know that term, but that's, you've got to have your asset sheltered for 5 years for the retirement assets, but they can hold post-tax assets.
Yeah, and in those situations, so minor, like if there's minors, sometimes it may be best to name the trust as beneficiary of your account after your spouse, because you're going to, the Secure Act made all
That's
those
pretty
changes.
common for us when we have someone that's done their estate planning. It's the proper process is make sure they're basically the trust is the contingent of all those accounts.
Yeah, and I always say it should be the final contingent, but it also depends on what their estate plan is saying, because if in a situation where there's a special needs trust, you probably want to pass it through the trust. But in a situation where you're giving 50% to 2 kids who are adults and it's getting outright, it makes more sense to name them as 50-50 secondary, because the tax rate through that trust is going to be a lot higher if you can avoid that.
So the phrase that I've always used, I've done about 17 years worth in the industry, is that you can run a trust from the grave. And it's so true, because
it really
if you're sitting, let's say you're a parent, you're sitting on, $2 million, your kid's a spendthrift or whatever it is, you can literally give them $1 a day for the rest of their life, and they don't have a say so in it. And to go into that, you were talking about going into detail and how far you want to go down. you can really be creative in the.
I mean, rich people are rich for a reason.
Sure.
They were real creative.
Sure. Like you're not getting this till you're 35 and you've demonstrated, you can write anything that you want in it. So, I mean, I always thought that was an interesting phrasing of the trust.
And it's true. And I mean, when we're talking trust right now, like standard revocable trust, it sounds complicated, but when you get into the world of estate planning, especially tax planning and the high net worth type planning, it's a whole different world. And the things you can do with those trusts are crazy. Like in all trusts, you have a lot of flexibility. But yeah, you see it especially with the big money. They don't want their kids. Yeah, they want it in the family, and that's it. And
that's why you see a lot of farm ground that stays, in almost in perpetuity. It's actually written in perpetuity that the farm is never going to leave the some farms never will leave the family bloodline.
Yeah, and that's something, and that's awesome. I wish more people with farmland, because it's constantly being bought up by corporations because people are they're cash poor in those situations. And the problem I see is if somebody needs to go into a nursing home or something, nobody has the money to be able to buy that land. And so it's getting pushed up for sale because, it's horrible. But things like that can be avoided with the right planning. Oftentimes an irrevocable trust of one type or another is probably the best answer, as long as that 5-year look back period. But yeah, it's definitely, if farmland is the thing, or anything, any real property that you really want to keep in the family, just take care of it now. I'm not saying necessarily do an irrevocable trust, because there's 100 different
a lot
factors
of depth there
I
that
would have to find out.
You're turning your assets over
exactly
away from yourself. I mean, by law you are, but I do want to point out, we are talking about some pretty, high level planning here. I think anyone that's sitting off to the side that may be intimidated by what you're saying, once you get in the process of working through an estate plan, I think it starts to resonate. Actually, like, we can sit here and talk and it could be very confusing, but once you're in the process, wouldn't you agree that you start to come around with understanding why you're doing it and the things that make sense?
Yeah, I mean, and I think that is the biggest, most important aspect of it, honestly, because I can't even tell you how many people have come into the office to like amend their trust, and I ask, what's in your trust, and they haven't transferred anything into it. And that was because the prior attorney, didn't explain to them, okay, now that you have this big stack of documents that's completely worthless unless you put your trust, your assets in your trust, this is what you do next. And so, yeah, I mean, I really try to talk everybody through it. Like I said, I've kind of seen patterns in what people get the most confused on and what people get the most hung up on in terms of making decisions. So we have forms that we try to use to get people to start thinking about this stuff. I'll talk through, what types of if you bring in an asset list, and I do this with clients every time they sign their documents, we go through the assets and I'll say, this should go in trust. This can't go in trust, but you can name the trust as beneficiary, so that you at least have a plan moving forward. And it is overwhelming. I mean, I've done it for 10 years, and there are things that I don't fully understand, especially with like the full, like the crazy tax planning type things. So you shouldn't feel overwhelmed is fine, but understand that you're not the only one who doesn't understand it. And the whole point of hiring an estate planning attorney is that you're trusting them, that they understand what they're doing and that they can do the right documents, and that you're going to end up in a good place. You just have to understand what's next to make sure that, you move forward with the right stuff.
Can you put a house in a trust if the mortgage is still written through the people who originally bought the house?
Yeah, I actually meant to bring that up earlier. Yes, mortgages are not usually an issue. Actually, they're never an issue. The only thing it comes is like if you refinance. So mortgage companies don't like trusts, but they don't prohibit them. They'll just make you take your property out of trust, refinance, and then you have to put it back in trust.
Gotcha.
But yeah, most people have mortgages, and that doesn't impact anything. Homeowners insurance is another question I get. I haven't seen it be an issue. There's been a couple that ask questions, but it doesn't change anything. Because again, it's a revocable grantor's like see-through essentially. So it's just like you, except we essentially create a bubble that houses your assets. But other than that, it doesn't change anything about how you control it or anything.
Interesting. So you can have your insurance in the person's name, Ryan and Jocelyn Sotman's name, but the house can be in the trust and it would still get paid out. If there was an insurance claim or something, it would still get paid out without, they wouldn't be able to say, hey, well, you don't actually own the house, so we're not going to pay it out.
In your name as trustees. So when we do a deed, that's the only thing I would handle transferring is the real property. And so we would do a new deed transferring your real property from your individual name to your names as trustees of your trust.
Gotcha.
So it's still the same person. You're just in a different capacity.
Gotcha.
Yeah.
I think we should segue into it is a lot, and that's on the revocable stuff. Yeah, we haven't even got into the. Are you still up for okay? Because irrevocable trust, that is the bigger one, the one that's to me is a lot heavier. It's more strategic planning for various specific reasons. And while we get into that, a lot of aside from the trust, and you were mentioning houses, at what point should parents start considering having their kids on the house? And maybe this will tie into the irrevocable side.
Never on the house
as they're aging, for the Medicaid planning. So because that is, you can have a lien on that. Mm-hmm. Do you ever see a scenario where the parents are 75, 3 kids, and they got the assets and the house is still in their name?
Yeah. So I would recommend that you don't put your kids' names on the house. Again, that's a similar idea as like a checking account, but if it's in trust, then it specifies how it's to be distributed after the fact. I'll start with that. But as far as that impacts Medicaid, so revocable, anything that's in a revocable trust is still available for purposes of Medicaid. It's still available for purposes of your assets and how much you have. The thing is, and this is all of our estate planning documents include a bunch of provisions in there and different authorities that allow you to do different gifting and strategies to do asset preservation if and when somebody needs to go into a nursing home or an assisted supportive living facility. Irrevocable trusts, I always say, there's a timeline. So if anybody is does not have a super a lot of money, or if you calculate out and you don't think that the amount of money that they have outside of the real property that you're thinking of transferring into the trust is not would not sustain them for 5 years, then that's when I would say don't necessarily look into doing an irrevocable trust or some sort of thing, but there are other strategies that you can do to ideally preserve that asset. For an irrevocable trust, it's something I like to do real property because it doesn't impact their cash flow. That all of their cash is still outside of the trust and therefore it's theirs to use. But once you put something in an irrevocable trust, it's not yours and you can't touch it. So you're not putting somebody else's name on it, but essentially what we're doing is making sure that asset can go to the next generation. Even
before it gets spent down on medical assistance
exactly.
down the road.
I mean, nursing homes, even down here, up in Chicago, I would say $10,000 to $12,000 minimum per month. Down here, I've seen $8,000 to $10,000 per month. So your money gets spent quickly.
Even if you find anything like the cheapest one, which that's not what parents or kids are going out there doing for their parents. But that's it. I mean, it will bleed your assets down.
Yeah, and we could have a whole conversation on the Medicaid side of things because I do a lot of that, and that involves dealing with the nursing homes or the supportive living facilities, all the different financial institutions to get your statements, and you could definitely do a whole thing on that. But I would say that irrevocable trust, outside of again, multi-millionaires doing that type of trust, I would say the other type that are the main reason I do it is, again, farmland is a big one, because if you have to go on Medicaid and that's your only asset, you have to basically sell it to be able to use that money to pay for your care to get on Medicaid. And nobody wants to be forced into that sale, and no more farmland should get bought up by any corporation. Like it needs to stay in families, and ways to do that are by the irrevocable trust, because once you're past that 5-year look back period, that entire asset that's in the irrevocable trust is not available for purposes of Medicaid. And so you can get your long-term care covered and keep that safe. I will say we have an appeal right now with the state of Illinois on one of our things that relates to farmland, and they're trying to change the rules. So it'll be interesting, but the goal is to keep that in the family, keep that in family-owned situations.
On that specific type of planning, is there a certain age that you see, the ones that need that are starting to process? I need to, have a meeting with someone like you. Is there a sweet spot, a window where someone that maybe hasn't done it yet should come and talk to you?
There's no particular window. I would say the sooner the better, because there's always some, like we can visit a situation now, and we can kind of plan for, okay, if this happens, if this happens, if this happens. But if you're already up here and you're in a position where, you need to go into a facility now, or somebody doesn't have the capacity to update their estate planning documents, there's a whole lot less planning we can do. Mm-hmm. So people like to get into a nursing home and then spend their money and then come to us, and, if there's some money left, to try to do it. But just better, way ahead of time, just to come up with a plan, to see if there's something you can do, and it will really be dependent on your total assets, what type of assets you have, what your physical and mental health is, and, status and capacity, because somebody has, early onset dementia, you could be a totally separate age than somebody who is in physically, mentally good health and lives until 95, but just can't walk right or something, like there's so many different things there. And your health is going to give it a clue into when you might need long-term care. We really could talk about this stuff for a long time, because I'm on a legislative committee for the National Academy of Elder Law Attorneys. And the biggest thing is we're trying to fight with, the state of Illinois to get legislation passed for these certain things. And the goal that I want is to be able to keep people in homes versus the nursing home route. And so just know that we're trying to get legislation passed that allows more for in-home care for that sort of thing, rather than having to go into a facility, because there's a lot of things that you can do, but unfortunately Medicaid doesn't cover in-home care stuff. But that being said, if you come in early enough, we can do things like a child caregiver agreement, all of these different estate planning tools that can, you can have a plan moving forward, rather than waiting until you're 80 years old and your spouse has dementia, and so now you want to try to figure it out so that you don't go broke.
Another good segue. We're mental capacity. Done what I do, and I've seen the scenarios where you can kind of an outsider can pick up on different cues a little easier than someone that's like you're around your parent every day. Mm-hmm. So you're starting to rationalize some of their some of their not their decision makings and the things that they're doing. And I think this maybe is a great opportunity to try to stress or maybe give some information of those cues for those people, because we don't want to see our parents, mental capacity diminishing, but it happens. Yeah. And we try to hang on to that as long as possible. And as an outsider, sometimes you're like, look, there's red flags all over. Mm-hmm. And sometimes parents don't want to listen. Is there any advice you can give just to, the listeners out here that you can help guide that, when you're hearing or seeing things, because that's when you really should start paying more close attention, because then there's abuse that could come in, which you definitely don't want to happen. I've seen it personally. It's ugly, and there's nothing you can do until their faculties are taken, at least from a medical perspective, to make decisions. So,
well, yeah, I mean, the capacity concern is the biggest reason I say it's always better not to wait to get an estate plan done, because in order to do your estate planning, you have to have the capacity to do it. And once those documents are in place, no matter when the capacity issue becomes a concern, you already know that you have somebody that you trust that is named to be able to assist you if and when that happens. As far as capacity goes, I would say it kind of goes both ways. I have people who come in who say, oh, well, they're fine. And you start talking with them. That's not the best. Like, they don't seem to know as much as what's going on as you are leading on. But a lot of times I'll have people who have come in and say, okay, well, we got a neuropsych letter and it says that she has dementia and that means she doesn't have capacity. And that's just not true. I mean, there are people who are clients who they may have capacity at 9 a.m. and then by 6 p.m. they don't have legal capacity because they have sundowners. And that's what happens with dementia. You can wake up and you can know everything that's going fine, but by 6 p.m. that person can legally not have capacity. But if you execute an estate plan while you have capacity at 9 a.m., that's a valid estate plan, and just because there's a diagnosis of dementia, I think everybody realistically and logically knows that doesn't mean all of a sudden that person doesn't have capacity. But some people like to take it that way and say, well, there's a dementia diagnosis. That means that she doesn't have capacity. No, that just means that her memory is a little bit worse or way worse. There's levels of it. And so, so capacity is a big thing. Abuse is a big thing. I wish financial institutions did a better job with that sort of thing, to be honest, because I feel like I'm fighting with financial institutions more.
Hands are tied. If you get an instruction and I'll be honest with you. I was sitting in a scenario where I had a client who was, giving me verbal instructions and I know behind the scene, I could hear, voices behind, they were giving him instructions. And I'm like, you have to take their instructions until you can't.
Right. Exactly. Well, and then you have other situations where there's a person who all of a sudden $75,000 in 3 days gets shipped out $75,000 a day, and or a bank is like, wow, that's not uncommon. There was nothing to flag there, so it's very interesting. But I will say that brings up a good point. That's another reason to have a trust in place, because banks, financial institutions, they don't like powers of attorney. And by law, they're not required to have a copy of that document on file. I always tell clients to give a copy to them so that they have it, so it's less of a concern. But because banks are concerned about liability, they're not fans of just powers of attorney. But if they have a trust and they name, they have a copy of that trust on record, so they know who's named second. They know what the terms are if you become incapacitated. Whereas if it's just a power of attorney, somebody walks in and says, oh, my mom doesn't have capacity anymore, I'm in charge of all her money. And the person at the stand is like, what? I've never heard of you. I've never seen you, So, having a trust in place makes that a lot easier too, especially for as you take care of it. And I'll be honest, a lot of the people that come in for estate planning, especially, nearing retirement age, it's because they just dealt with a parent and they just saw what a nightmare it could be or how great it was. I've had both sides of it, but they personally are like, okay, what do I need to do to avoid that sort of thing? And so, I mean,
what a wealth of knowledge you are. If someone has something in existence, I'm assuming you'd be glad to review that for them and find as part of your offering.
I could. I don't usually review documents unless there's something specific. I will say if it was prior to 2020, I mean, a standard thing is that you should revisit your estate plan every 4 to 5 years, or upon a major event, whether a child, becomes an adult, or you have another child, or a spouse passes away, or you retire, you move, all those sorts of things. Any big event, you should revisit your estate plan. I'm not saying change it. Just revisit it, make sure it has what you want, and then go from there. Anything prior to 2020, there was trust code changes back in 2020 that changed a lot of the trust law. So if there's a document prior to 2020, unless it's some specific reasons, I usually say you probably want to fully restate that trust or fully update your estate plan. Wait, where were we going with that? I'm sorry, I just lost my train of thought.
I was asking about if someone already has an estate plan in place.
Okay, yeah. And so revisiting it, I'm happy to review documents, but, if I'm reviewing it, that's going to be an hourly charge, and I don't necessarily know if it's worth
Was update maybe a better...
Yeah, I'm happy to update your estate plan.
Okay, I think that's what I was asking.
I'm happy to review it, but even just looking at it, a quick look at it, the date, how long it is, some of the provisions that are in it, I can tell you whether or not it's good for your situation. But yeah, I mean, I'm happy to update your estate plan. And if there's something that I don't handle, I'm happy to refer you elsewhere. Yeah.
Okay.
Yeah. Whatever needs to be done.
This has been awesome. We could, you're right. We could keep talking probably to the point where we wouldn't have anyone even watching anymore. How do people get in touch with you?
So I'm fully remote. I think we talked about that. I'm fully remote, but so most of my consults are via Zoom. I have a website out there. Mine is www.foxlawadvocacy.org. You can do it. You can contact us that way. We have a consultation thing that you can sign up. My email address is paige@foxelderlaw.org. You can contact me that way. And then, like I had said, I also work for Dent Colson Elder Law in O'Fallon, and we have an office in O'Fallon. And you can find their website online too.
Okay. Well, I will tell you, we have had a lot of people sitting in here and doing these interviews. To me, this should and hopefully is, from a value perspective, an impact episode. We celebrate events and someone opening a new business or, hearing someone's story. This is a different angle today. And I really, really hope that one person, if not multiple, hear this and get up off the couch and say, I'm going to pick up the phone, whether they already have someone in mind or that happens to be you. I feel like this is a value add for the community, just to provide some insight to a very, very needed service that you offer. So, I mean, I really personally thank you for coming on. I think it's been awesome.
Absolutely. And I just know, it sounds a lot more overwhelming than it is. And a decision to not do something is a decision. My boss always used to say that, and it hit home because, it's hard and people get frozen in kind of fear or now what when they see these things or when they hear about it. But you can, if you find the right attorney, they can walk you through it, and it really is less overwhelming, and it's just a peace of mind that it's there and it's done and you can move forward with it.
There are consequences to an action.
Yes, or non-action.
Correct.
Well, thank you so much, Paige.
Yeah,
it was great having you on.
It's great.
Great to have you back in town as well, by the way.
Excited, yeah.
Good luck on your trapeze venture.
Wait.
All right,
Circus,
thanks.
that's next. Right. Thank you.